Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Friends, normally you will be under confusion in two or three aspects. We are going to discuss those two aspects regarding section 167 CRPC and regarding section 170 CRPC. So, as regards 167 CRPC, please remember what is custody. Custody means normally 167 goes to say about the judicial custody. Sometimes they may hand over to the police, that is police custody. So judicial custody and police custody, these are the two terms used when we are discussing this section 167. But now house arrest, it happened in the case of Gautham Navalaka. This whether house arrest is called as judicial custody or not at all any custody. This is the doubt some of the students got. So section 167 says procedure when the investigation is not completed within 24 hours. Normally the basic thumb rule is that the investigation has to be concluded within 24 hours, which is almost not possible. Of course, in certain cases we have completed investigation by the charge sheet also, but that is rare instances. So if you are not able to complete the investigation, then you can't keep the accused. Even according to 56 and 57, the arrested person should be produced with the court within 24 hours. So you have to produce him before the court within 24 hours. But the investigation is not completed. What to do? Then you have to produce him and ask for remand by the judicial magistrate. The magistrate, whenever such person is produced before him, then he will order him to judicial custody, not more than 15 days. Of course, 90 days, 60 days period, you know, right? If that is there, if that is charge sheet is not filed within the period, then he will have a statutory bail. Nowadays, so 167B of the CRPC is also there. So the person need not be personally produced. He can be produced through video conferencing. Actually, this is the main work of Sri M.V. Krishna Rao IPS. When he was working as the DG prisons or IG prisons, he has taken it to the notice of the Supreme Court. Ultimately, the government has considered it and 167B has come into existence. Right? So, whenever you are not able to complete investigation, the court will grant the judicial custody. Till such time, he will be in your custody, police custody. Ultimately, even while during the judicial custody, if the police asks for the so-called police custody, then the court may grant police custody, and definitely you have to produce him before the medical officer. After completing your interrogation, the police, they have to produce him before the medical officer, then only submit him to the court. These are all generally known points, but the important point is, in the case of Gautham Navalaka versus National Investigation Agency 2021 Bhima Koregaon case, on 5/12/2021, in crime number 4/18 under section 153A and 505 class 1 or 7 of the IPC of Pune, Sivargam or someplace, Pune PS, the case was registered against Gautham Navalaka, Tettumbide or some, the knowns I can't say. So others, and in this connection, they have very recently ordered for the house arrest of Gautham Navalaka. Whether it comes under judicial custody or police custody, definitely it is also judicial custody. So 167 says if any person is ordered house arrest, it is also judicial custody. So please remember, this is an important point. Some of your friends, they are getting it out. And now we are discussing regarding section 170 CRPC. 170 CRPC, when 169 says if there is no material against the so-called accused person, the investigating officer can leave him. If there is material according to 170 CRPC, he can send him to the court or he can file the charge sheet even as per 173 CRPC. So in this connection, some of the magistrates are under the impression, I can say it is wrong impression, under the impression that The accused has to be arrested before 170 crpc. Arrest of accused is necessary to grant him or to be forwarded to the magistrate under section 170 crpc. The statement is not correct. It has come in I think in an examination also. This statement is, it has given an objective type. This statement is not correct. So please remember, law does not mandate arrest under section 170 crpc. And arrest can be done, arrest may be done only when required. You can file the charge sheet even the person is absconding. So this was stated in the famous case of Siddharth versus State of UP 2021. Here the Supreme Court held that the special judge was under misconception that person in non-bailable and cognizable offence has to be arrested invariably before the filing of the charge sheet. Not necessary. So section 170 reads, cases to be sent to the magistrate when evidence is sufficient. Yes, you can send him to the court. So these 2 points, if you are able to understand, it is sufficient. So house arrest is also coming under section 167 crpc. A person need not be arrested if he has to be produced to the magistrate under section 170 crpc. And I have told you Gautham Navalaka versus Siddharth case. So please read the cases thoroughly and enrich your legal knowledge. With this, I am concluding. Thank you very much.